Hi everyone, this is Joseph. I'm here in Los Angeles and we're going to talk about immigration today. And there's two things I want to specifically talk about. It's the new $1 million green card, the Trump card, and also everything's been talking about the H-1B, the new 100,000 H-1B. And there's so much misinformation and things that people don't talk about. With good intention, that's fine. But because we do so many of these cases, I want to talk about the nuances of it very specifically. And then we're going to talk about a success story that we've done. It just got approved 10 days ago. It was a waiver for fraud and misrepresentation. So how did that case get approved? What was their circumstance? How did USCIS approve it and the consulate approve it? And now the clients are able to finally be reunited in the US. What happened? I'm going to go through everything. And if you guys have any questions about immigration, about your case specifically, feel free to ask questions. While we're here live on TikTok, we're here live on YouTube as well as Instagram. So if you are watching from anywhere, hi, and we'll get right into it. Okay. So the first thing is let's talk about the gold card first. The White House has announced that you can now buy a green card, but I want to be very specific about the buying part because it is not a contractual relationship. You are gifting $1 million to the U.S. government in order to be in line to apply for a green card. Okay, that is the very big thing that most people are not talking about and not understand. Like, why would I gift $1 million just to wait in line to apply for a green card? Because the caveat is your green card can still be denied even after you gift this $1 million. It is not a contractual exchange. Many countries around the world have these citizenship buying status programs. We could create a list. You could go watch it later on. But yeah, you can spend a couple $100,000. You could buy real estate. You could buy something in that country and you could get directly citizenship. You can directly get a passport. We've seen tons of these happen from Grenada to Turkey to lots of other countries. The United States, now the very first time, is creating its own pay-to-play program. But the caveat is you don't get citizenship. You don't even get a green card. You get the opportunity to buy a green card, to apply for a green card. And the way it is entirely orchestrated, and we'll go through the reasons behind why, the way they're doing it is by saying, if you can gift $1 million to the U.S. government, then of course you must be an extraordinary individual. Of course you must be of national importance, and you receive a national interest waiver. So that's the EB1 and EB2 category. This is not the EB5 traditional investment program, which we'll talk about later. This is now moving somebody who is now gifting the money to the U.S. government. And the U.S. government says, okay, well, since you have demonstrated you are wealthy and you've gifted us, we will consider you of national importance. So we'll qualify you under the Einstein Green Card program, which we do a lot of. So most people who don't understand the EB1 or the EB2 and IW type cases is essentially you show your resume, you show your LinkedIn profile, you show how extraordinary you are, and the government accepts that resume. They give you a green card. Sounds amazing. We do tons of videos. You can watch it out. There's dumpling chefs that we've gotten green cards through this programs as well. You show you are better than your peers in your industry and you get a green card. Now, within that law, there is something called the comparable evidence, which means show us anything to show that you are better than the rest. And if we can accept this comparable evidence, then you are of, great importance, and so we'll give you the EB1A green card. So essentially what this administration is doing is saying, hey, if you are wealthy, you must be extraordinary. That is exactly the logic behind this program. And so when you qualify for that, then you can directly jump the line and be able to apply for a green card. But again, it just means your, maybe application can get approved to qualify to apply for a green card later. You gift the U.S. government $1 million to prove you are an extraordinary individual. This is a very Trumpian mentality. If you're rich, you're extraordinary. If you're rich, you're capable. If you're rich, you're of national importance. If you're rich, then you are not the terrible criminals that the prior administration has let in through the border. So they're juxtaposing what the prior administration and previous immigration law have allowed through the country, and politically they want to say, hey, instead of them, which ICE is trying to deport, we're going to allow these type of people in. And who are they prioritizing? Who are the people who are really important to the United States? Rich people, wealthy people. And so they categorize it under the EB1 and EB2. That's one reason. But a second reason that most people don't understand is that there's such a big problem with putting it under the traditional EB5 program. Because under the traditional EB5 program, where you're investing in a company to hire workers, there's a big source of fund proof that's required under the congressional law for EB5. But under EB1 and EB2, it's just a comparable evidence. So they're not under that same burden with having to prove the source of fund. That is another major reason why by moving the investment traditional EB5 to an EB1, EB2, now they're just saying, well, we're not dealing with money. We're not money laundering. We're not an accomplice in moving illicit funds. You gifted it to us. We just assume you got it rightfully. And we are just adjudicating whether or not on a comparable evidence you are a person of national importance and you're extraordinary, right? And so, of course, we haven't seen the actual fine print on how they're going to adjudicate, but that is one big hypothesis the immigration lawyer community have been saying, because if the $1 million needs to qualify for the source of fund proof, it would be extremely disastrous and very few people will qualify and apply for it. But if you relax those rules, which under this scheme can be done, then it would actually potentially allow for many people around the world to qualify for this $1 million gift to wait in line to apply for a green card. And you might say, this is ridiculous. Why would anybody do that? Well, the current situation is a lot of people are spending and investing $1 million to set up a company to hire U.S. workers because they want to qualify for under the EB1C category to get a green card, or they have to spend a lot of money to be published, to do huge events in order to prove that they're the best of the best. And, again, that is money that is spent on agents, on U.S. workers, on contractors. But now the U.S. government is essentially saying, let's cut out all the middlemen, right? Basically, the White House and Trump in a very businessman type of way. Why give it to all these regional centers for them to invest and build up their hotels and golf courses and all sorts of projects? Why don't you just invest in the U.S. government and then we'll give you the green card? There's a good reason why in the past, it's not a good idea to do this pay to play kind of a scheme. Because imagine if somebody did spend $1 million and then you deny them from some bogus reason. Then it becomes, well, you're almost defrauding people. It almost sounds like fraud. And in this case, the way the U.S. has positioned it is you're just qualifying to apply for the green card, but you don't actually get it yet. So it's one step away from everybody else, but in other countries. You might say, well, other countries can invest $200,000, $300,000 and get citizenship because, again, they're not, the strongest and most powerful country in the world. So in the U.S., they're making the price tag $1 million as a gift, no strings attached, just to apply. So you still have to pay for all the other fees just to get a green card, which means it could totally be revoked by USCIS for any other reasons, which we have seen now. If you have DUI, if you have any other inadmissibility where the customs officer at the airport can determine, hey, you might have abandoned your green card, they could take your green card away and poof, everything you previously missed was off, right? So that is the Trump $1 million green card investment. We will see more details and I'll definitely share more about it. But again, who does this harm? The prior immigration system that we've had, people have to be extraordinary, best of the best in their field. They have to be executives, hire a lot of U.S. workers. They had to invest in businesses that hire U.S. workers in places with high unemployment. That's the way to get a green card. Well, now the U.S. government steps in and says, nope, just give us the money. We'll use it how we want to use it. We want to use it for whatever we want, right? Because it's deposited to the general treasury. And then we'll allow you to have that status. Is this good for America? Is this bad for America? What do you think? So that is the Trump card. But I could tell you, a lot of people are very interested. And so depending on these few things, if you do qualify to apply for green card? Do you have to wait for the priority date? Do you have to prove the source of fund? If both of those answers, if there's an expedited way to file your case so your entire family can stay here, and if you don't have to do source of fund as stringently as EB-5, there will be a lot of demand and a lot of people will do this as opposed to the other things. So is this good for America or is this bad for America? I think we'll see.
Yeah, some people say the green card process already not cheap for normal people.
The green card process is already not cheap for normal people because, yeah, it is tens of thousands of dollars and the timing is crazy long. This is just that much more expensive. But there are plenty of people who will gladly do this. Just think, right? Some people who have a small condo in Tokyo, in Seoul, in Russia, in London, you sell a small flat, you have the $1 million you invest, and you get potentially a green card in the US. That is extremely valuable to a lot of wealthy people. There are top 1%ers in so many countries around the world. Before, EB-1A, EB-2NW, EB-5, too risky, too complicated. Now it's much more streamlined. So if this does end up working, I would easily guess there will be more than 10,000 people who would apply for it per year. I'm sure you've seen H-1B is supposedly for rare, specialized, unique individuals who the U.S. desperately needs. That's just not true. We have done thousands of H-1B applications at our firm over the years, and I could tell you that's not one of the requirements. The way to prove somebody deserves an H-1B, you prove that the client has a college degree or master's degree that can fill that position and that it's specialized. It cannot be too general as long as their education meets this particular job in the past, in the present, or in the future, right? So you can imagine there's a company that might need a data scientist in the future. They never had it in the past. They don't have it currently, but the client, the beneficiary is a student who studied data science and they need it in the future so they can petition. Nowhere does the application talk about the US's need and how they cannot find another US worker, right? That's not part of the application. We already go way above and beyond in our H-1B applications, that we argue all 4 points, that the company needs it, that the client fulfills it, that the job duties are extraordinarily difficult for this job, and that's why they need a college education, and why at the industry level, everybody else needs it as well. But those are the core things to qualify for an H-1B. So you see, I'm seeing at least a lot of other people say H-1B is for these rare individuals and super specialized and super needed, but they're giving it to like random people. That's because the application process does not require it, right? The L-1B application requires to prove, hey, your knowledge is so specialized that you learned overseas, or you have this innate special knowledge about your field that the U.S. employer cannot find in the U.S. Okay, then we give it to you, right? The EB-2 requirement shows that you need to advertise and try to hire U.S. workers, and if you cannot hire U.S. workers, then we have to give it to a foreigner, or that your position is so of great importance nationally that we could waive this requirement to that even though you could have hired a U.S. worker, we're still going to hire you instead. Those other visa categories have these kind of protections built into it, but not the H-1B. So that makes me really question the intent when the White House is issuing this statement, because I think it actually harms most Americans. Let me break it down for you, right? So the big tech companies supposedly is behind this and they are in agreement. But you know why? It's because they benefit from it. Let me explain. H-1B, for as long as I can remember, the past 10 plus years, have always had a lottery system. The U.S. desperately needed a lot of tech workers to come into the country to fuel our growth. And of course, if you lived here, if you've seen the world at all, you've seen how the U.S. has advanced in their technological endeavors with all the big companies. Okay, so granted, H-1B helped a lot of that. Why suddenly it's not needed anymore? Because of AI, right? AI has completely reduced the crazy need for coders, for basic IT, and for entry-level positions. And based on everything we've seen in the past few years, a lot of tech companies have laid off a lot of people. Here's the thing. A lot of these companies have already applied for scores and scores of H-1B applicants over the decades. And each time they get it for years. And based on other immigration law, you can get an H-1B indefinitely if you're about I-140 approved, which means all these tech companies in the past 10 years, they've already filled up their ranks with the best of the best H-1B applicants, and they even have a super long wait list. They even had to fire a bunch of them. So they've already eaten enough H-1B. That's a crude analogy, I understand. But look at the policy now, right? The policy is saying new applicants have to pay that $100,000 fee. Guess what? These big companies don't need to do that. Who needs to do that? New people who are competing, new people who are new companies who are trying to pitch in New Yorkers. Well, now suddenly they can't get the H-1B anymore. So this new policy, does it harm the big companies? Or does it benefit the big companies by preventing other people to hire H-1B to compete with them? If you look at the facts and the data, it definitely protects the big companies. And that's why I don't see the big companies coming out and really rebuking the administration for this H-1B policy, because it benefits them so much given what's going on, right? It protects other people from doing the H-1B to compete against them. They, again, don't have to pay the $100,000 for all the people who've already gotten it. And here is the last thing. It is a strict $100,000 mark. $100,000 in San Francisco is not the same $100,000 elsewhere in the country. Fair? $100,000 for these tech jobs is not the same as $100,000 for a desk job somewhere else in a different industry. So, with a price tag of $100,000, who can afford it? Big tech companies can still afford it, but everywhere else in this country, a lot of red states, a lot of small to medium-sized companies who had to hire their very first H-1B applicant, well, guess what? Now they have to pay this crazy fee. So again, who does it benefit? I feel like it definitely benefits the big companies again. It harms the small to medium-sized companies who are only applying for a few H-1B applicants a year. It harms the industries who do not have a high salary. And again, you're prioritizing tech. So with all the talk of this memo's, the first 2 pages is blasting big tech companies. If you read it, and I've read it many, many times, it's blasting big tech companies for using the H-1B to their advantage. So this rule supposedly is to punish them. Guess what? When I'm reading through the lines and seeing how it plays out, it benefits them more than anything. It benefits their industry. It benefits the fact that they have previous H-1B applicants. It benefits the fact that AI, suddenly they don't need it anymore. So this policy comes out. So again, is this policy to score political points? Or is it to really punish or to protect the big companies? Or is it somehow to harm mid-sized to small companies? I don't know. But from the way I see it, the stated intent of this policy and the actual unintended consequence, there's a mismatch. And so I'm calling it out, right? I'm an immigration lawyer specialist. I do H-1Bs all the time, and I just don't see things adding up. If the administration really wanted to do what they stated, they could do a lot of different other things. They can spread it out and say, oh, if you already had so many H-1B applicants, and if you previously fired employees, then you cannot do H-1B, but everybody else can. But you fired a bunch of U.S. employees, so you cannot do H-1B anymore. Boo, you. You can separate out by industry, right? So, different Arizona, Iowa, different areas that actually really need H-1B applicants because there's not enough college graduates who can really do great work there. Maybe they can still do H-1B and not pay the $100,000. But if you've already hired more than 5, 10, a percentage of your workforce is H-1B. So, right now the cutoff point is just 50%. If you have 50% or more of your workforce is H-1B, then you get fined a little bit. Why don't you drop it down to 10%, right? If 10% of your workforce is H-1B, then you have to pay this $100,000 fine. But why punish the little mom and pop shop that only has 5 employees and they need this one H-1B applicant? Here's the thing. If you make companies not hire H-1B, you are not going to directly increase the number of U.S. workers you hired. Let me explain why, okay? A lot of people say, and it's that it is not going to, but they don't explain why. Here's why, right? When you want somebody on an H-1B visa, you first have to go through the lottery program in February or March. That means that person has already been hired by your company. You want to hire them. They went through all the interview. By February, you like them enough more than everybody else, and you're willing to submit a lottery, an application for them, and pay thousands and thousands of dollars just so USCIS could approve your case. Other people you can hire, you don't have to pay the $1,000, but this person you like so much, they're so important, you have to pay $1,000. And guess what? Even after the approval, they don't get to start working for you until October. So you have to wait an additional 6 months or longer. And then after they start working for you, they can change to any other employer and who sponsors them. So you're taking a big risk. And if you do fire them, you're supposed to pay for their plane ticket back to their home country, which is another sometimes a couple $1,000. And then if you don't do their immigration paperwork correctly, they can sue you and you're liable. And then guess what? It's not a flexible position. Whatever you stated for the application for the H-1B, if there's a material change, you have to pay the thousands of dollars again to amend it, which means, most jobs, you hire somebody and within a couple months, you change them to a different position, you change them for a different role, you change them to another working location, you let them work from home. There's a lot of flexibility because businesses need to adapt to changes. But for an H-1B applicant, the job duty, the job pay, everything is fixed. What normal employer would go through the hardship and the headache to do an H-1B application? Let me tell you. The employers that are willing to do the H-1B applications is because the candidate is so good that they're willing to wait for them, to do it for them. And if it's not for them, the job just would not get done. They just wouldn't do it. They would not hire somebody to fill that position. They wouldn't wait. They wouldn't spend that much time. It just wouldn't exist. So the people who are applying for H-1B, they are coming here to do jobs, generally speaking, that nobody else is going to do anyways. Or if they are going to do it, it's just already built into their normal job duties. Okay, that's, I think, something that most people don't understand. The H-1B process itself, so convoluted, so expensive, so long, that no normal employer would choose to voluntarily go down this path if an easier option was available. And again, the memo, the White House proclamation is saying these companies use H-1B to drop down the wages for other workers. Again, there's so many easier ways to solve that problem, right? Reduce the number, instead of 50%, make it 10%, make it 5%, make, particular positions that, are more susceptible to fraud, such as the IT jobs, instead of wage level 1, make it so that it's mandatory wage level 4. There's so many ways that you can solve that particular problem, but the 100,000 price tag, it looks amazing on all the news channels. You scored a lot of political points, but is it going to do what you stated? I don't think so. So we'll see what USCIS clarifies. We'll see how the lawsuits play out. We'll see how things gets amended. But I just don't like it when people say one thing and do something else, or there's ulterior motive. So I'm just calling out what I see. I see some questions. I'll answer questions first, and then I'll jump into the next story.
I came here legally, been a permanent resident since 2010. I'm on probation for CPS. I pleaded guilty for a charge I didn't commit. Can I apply for citizenship if on probation?
Our firm don't recommend anybody apply for citizenship while you're still on probation. We've just seen too many cases get denied without adverse consequences, as in, maybe you just have to repay the application fee and reapply again later on after the probation is done. But we've just seen too many good, well-intentioned, well-positioned cases. They have good moral character on every front. It's just that their probation is not over yet. The officer says, sorry, we just have to deny you. Or they hold the case and say, we'll give you another interview notice in about 6 months when the probation is over, and then you come back. Why that is the case? Maybe it's just easier for these officers to adjudicate cases. Maybe there's an internal memo somewhere when they say, hey, just wait for the probation period to be over. That way they've already paid the consequences of their crime, right? They are not judges in a state law courtroom nor a federal law courtroom, so they don't know exactly the ins and outs. So it's just easier for them to draw that bright line, But again, That's just from anecdotal and personal experience. So I would totally recommend wait until the probation is over before you apply.
My 751 was approved based on extreme cruelty. Can I naturalize in 3 years or 5 years? I was married to a U.S. citizen.
5 years since the day you got your first conditional green card. Now, if you get married to another U.S. citizen, that's a different story.
I applied for asylum, married a green card holder. Can she get me a green card?
Yes, slightly complicated. She needs to petition for you. You have to wait for the priority date. Assuming there's none, you can file adjustment status. You have to close out your asylum case and then transfer it over. Because you have an asylum case prior, then in the marriage-based application, the standard of proof is much higher. So you have to prove it's not just the normal preponderance of evidence. You have to prove clear and convincing because of the asylum application. So you need to do a much better case. So if the case itself is weak, I wouldn't necessarily go through all of that immediately, because then you'll be in a worse situation where you close your asylum case and your 45 I-130 gets denied because of the higher bar. So you definitely want to maybe even draw out your asylum case potentially, and then build up your new marriage case so that it's much stronger before you execute. So lots of little details to kind of figure out, but the short answer is yes.
I got denied for a J-1 waiver, and now I'm just lost and confused. My home country approved, but DOS denied it.
I would say try again, maybe. People deny all the time. Don't take no for an answer. You say, we tried our best, but now we have some more additional evidence. Please see if we can get approval.
Mm-hmm. And it probably depends on why they got denied, right?
Sure. Yeah.
Will the 100,000 H-1B fee apply to cap exempt university H-1Bs?
We are still waiting for all the details on it. My hope is that it will. My hope is that the 100,000 fee only applies to foreign educated individuals who are coming to the U.S. for the very first time, first application. So if you already received it in the United States when you're going abroad, visa doesn't apply to you. If you're U.S. educated, U.S. institution, hopefully it doesn't apply to you. If you're a nonprofit, hopefully it doesn't apply to you. So I'm hoping there's going to be a list of exceptions, but we'll see in the next 90 days.
I was born and raised in Saudi Arabia, but I'm an Indian citizen. I got my master's. Can I apply for EB3?
Run the question with me again.
Born in Saudi Arabia.
Okay.
Indian citizen.
Okay.
Have master's degree.
Okay.
Can I apply for EB3?
Nothing tells me you can, right? So where you're born, what citizenship you have doesn't apply. Having a master's degree, great. Even if you only have a bachelor's degree, if you have the requisite work experience, you could even apply for EB2 or EB2 and IW. So yeah, nothing you said disqualifies you from EB3 or EB2 or EB2 and IW or EB1A, right?
Can a U.S. citizen child file for his father with a pending VAWA case?
Yes, you can have multiple applications filed for you all at the same time, should you want. So if the father is on a VAWA case, but if the child has already gotten eligible to petition for you, then they could file that way. If you have an employer that wants to petition I-140 for you, they could also do that. There are multiple ways that you can try to get a green card at the same time.
How long after I'm off probation should I wait to apply for citizenship? Is it just day after? Or?
Yeah, we usually do day after. So while you're on probation, you can prepare a really strong case, right? So don't start preparing, right? Don't wait to prepare, right? So do your good moral character analysis, do your good moral character case brief, talk about your ties to the U.S., talk about your contributions, your taxes, your community, do all of that. And then the moment probation is over, get the court transcript, certify it, and then the next day you can file.
So I want to adopt an undocumented child. Regular adoption attorneys can't help. Immigration attorneys seem not to be able to help, at least with the adoption part. Why can't I just adopt the child if his parents are giving me approval?
There's lots of reasons. We did a lot of these in the past, so I can share that with you. One, the U.S. laws wants to prevent child trafficking, right? So the whole Hague Convention is really set up to prevent child trafficking from around the world, and a lot of that happens. You can feed and care and love a child. No one's going to stop you. But when you formally adopt a child in state court, then you suddenly get legal responsibility and legal rights for that child. And then when you want to petition them to help them get a green card, then again, you're passing on your status to the child, so the child could get legal status in the U.S. So that becomes another different issue, right? And so if the parent wants you to care for the child, that's contractual between you and the parent, that's fine. But if you want to receive government benefits from the state through a formal State Department, state court, then obviously an adoption court needs to be able to prove that. And if you want the child go from undocumented to documented, you need to go through the immigration court, which immigration USCIS processing, which requires a state court adoption. But just so you know, adoption attorneys can help you with the adoption, and then once you're adopted, potentially immigration lawyers can help you with the immigration petition. So it is possible.
And would the undocumented child be able to fly back to their home country without being detained?
Once they get the green card, then they can fly. It's not like asylum where you're renouncing, your country, you're proving that you've been persecuted or whatnot, right? So a lot of times adoption happens because they lost contact with the parents, or the parents are forfeiting their right to be a citizen, forfeiting their right to be a parent, right? And so, once they get adopted, once they get the green card, they could still go visit their parents, but it doesn't mean they can't fly.
So my B1 visa was denied. My SV1 visa, was denied. Should I reapply if I already have a B1, B2?
SB1 denials are very common. It's very rare to get them approved. Once SB1 is denied, if you have a B1, B2, congratulations, at least you're able to still fly to the US. But if you want to save your green card, if you want to be able to come back into the country as a green card holder, you can explore going through CBP, right? And so we made probably over 80 videos on our YouTube channel talking about how to present your case, all the 140 plus reasons to prove you did not abandon your green card. So we've done plenty of cases where SB1 was denied 3 times, but then the customs officer approved it and they were able to basically get their green card back. So don't lose hope. It's still possible based on your facts.
And then as someone who graduated college in Europe, what would be a realistic pathway to live in the US with the new guidelines in place?
In Europe, depending on what country of citizenship you have, so it doesn't matter where you're born, right? Somebody can have multiple citizenship. One of the best visa categories in all of US immigration history is the E2. So look into that category. We know plenty of people who prefer the E2 even above a green card, because there's no worldwide taxation. So if you're educated abroad, you have the skills, you have the insights, you have the investment, you have the ability to create value in the US, you could potentially do an E2. And if you are educated in Europe, assuming you have a particular nationality in Europe, it's probably a key part of the US, then you can execute your E2 plan.
Is there any update on a possible lawsuit against the H-1B fee?
There will likely be a lawsuit just because we see that happen all the time. It will be initially a temporary restraining order, so it'll probably get postponed into a preliminary restraining order injunction until next year. So we don't know if it will necessarily go into effect until next year, but a somewhat of a modified version of that will probably end up playing out eventually, now that this hand has been shown.
I don't have access to my son's birth certificate. He doesn't live with me. Can I do my N400?
Yes, but you run the risk of, at the interview, the officer will ask you for the birth certificate, and you might have a request for evidence to have to produce it later on. But you can definitely still file, try to do your best to get it, and try to explain to the officer why you don't have it.
I have 3 years of work experience as a business analyst. I have my master's from the US. How can I get my green card? So there's obviously the marriage route. There's obviously the normal green card route for everyone. So EB1s, EB2s, EB3s.
There's also now the investment route, EB-5, to start your own business, or now you gift $1 million to the US to qualify for the Trump Gold Card. So there's a lot of different options for you to consider. You have a degree, you have a job, depend on your nationality, you could get certain visa and then for an employer to sponsor you.
What if I got married, I haven't filed yet, and ICE comes to you? You have no legal status.
Yeah.
Beside like a courthouse marriage and a marriage certificate, what else do I need to file my marriage petition?
What was about ICE? ICE already picked you up or what?
It seems that way, yeah.
So if ICE already picked you up and you're already in detention and you don't have a 45 receipt to kind of shield you, they might make it a mandatory. Well, actually, I know they will make it a mandatory detention, so you can't actually get out, and so you are now stuck in detention center. So, if ICE didn't pick you up yet, you can file as fast as possible on I-130-45 and get a receipt, so you can use that as a shield. But if you haven't done that, it might be too late.
Can deportation orders be stopped by a step parent petitioning for legal guardianship?
Nope.
My dad did biometrics in July for a T visa and I-765. Will he get a work permit soon or wait 2 years?
Work permits are usually granted within 6 months to 9 months. So from the date of filing. So if you got your biometrics, probably get it soon. Unless you don't qualify for the work permit, right? So that's entirely possible.
Have you ever seen a green card holder minor being deported for staying abroad for too long?
So the interesting thing about that question is, if it's a minor who has been out for too long, it's not so much they're deportable, it's more so they're inadmissible, right? Because deportable means you're in the US and then somebody goes and finds you and says, hey, you stayed in that outside for too long, we're going to deport you. So that obviously doesn't happen because you're outside. Now, if you're outside for a long time, when you come back in, the CBP officer at the port of entry, whether it's at the airport, land border, or a boat, they might say, hey, look, you've been out for too long. We think you've already abandoned it. And so it's up to the immigration judge to decide. As a green card holder, you are still a green card holder up until an immigration judge takes it away. So they still have to let you in. That's the thing that most people don't understand. They still have to let you in, but the officer could take a green card away and give it to an immigration judge. So if your question is, as a minor, been outside for too long, when I'm coming in, is there a chance that the CBP officer could confiscate my green card and give it to an immigration judge to decide if whether or not I have abandoned? The answer is yes. Right? We've definitely seen those before.
Can I still get a green card after my husband's death?
Yeah, it's 204L, I believe. So look up 204L, humanitarian relief for widows. There's a couple requirements, right? If your husband passed away, hopefully you're in the U.S. legally at the time of his passing and he petitioned for you, it's valid, and you're just waiting for priority date. So if you fit under those circumstances, you can still petition and get a green card. It's a small exception. Most people are not in the U.S. Most people are not legal in the U.S. when something like this happens. But if you do qualify, right, just search up 204L. It might work for you.
My F1 is revoked due to an ongoing case, but I'm not convicted yet. Can I still fight to get my F1 back?
Yeah, F1 reinstatement, right? Depending on the facts of your case, you could try to persuade an officer. You can even potentially leave the country and come back in, reactivate a new I-20 and SEVIS. But it really depends on the fact patterns of your case and how the CBP officer would adjudicate or USCIS officer would adjudicate your reinstatement.
I filed for a Form G325A with a work permit. How long does that normally take for deferred action?
I don't know. I right now don't have the numbers and the timing off the top of my head.
I filed. Can someone get naturalized with a dismissed misdemeanor?
Yes. Well, you could naturalize even with a convicted misdemeanor.
Do you think a temporary restraining order for this H-1B will be pretty quick in coming? I'm a physician myself and directly affected.
I would be extremely surprised if ACLU, if any other organizations, does not file a temporary restraining order on it when USCIS announces their rule, right? So White House proclamation, it's just, a web posting, like a long Twitter. But when USCIS comes out with a formal guidance, then the injunctions will come.
It's crazy that they haven't released a formal, because like October 10th is only like 2 weeks away. So everyone has to enter.
Yeah, it is crazy, but that's what makes the news so worthy, right? And so, our president is a master at getting media to draw attention to him.
What's going to happen to H-1B1?
Again, we'll see when USCIS comes out with the rules, right? What's going to happen to H-2s, right? Nurses and all sorts of things. It could all be affected.
And the other thing too is lawyers, right? Like CBP and USCIS, they're no longer communicating with AILA too. Do you want to talk about that?
Well, they're not formally communicating with the lawyer associations to plan out things on a national level, but we do still meet with them at the local level. And so there's still a lot of discussion, but that's more so for individual cases, right? This thing is such a national scale and policy that local chapters, service centers, they don't know either, right? So they're just listening to whatever is on top, and then it's up to Congress and it's up to the courts to kind of hash it out. So everybody's kind of throwing up their hands in the air, right?
So, okay, we'll take some other questions now. Filed U visa in 2021. I haven't even received my work permit. Do you know what's going on?
We don't do a lot of U visas, so I can't give you the timeline. But USCIS has been extremely slow with work permits. That's just, what we know. Like some people who did EB-5s and invested $1 million and they still didn't get their work permit for like a year and a half, and we have to sue them, right? So I understand the work permit situation is just completely chaos. U visa is a little bit more so, but again, I don't have the, stats to help you figure out for U visas.
Is there a way to get approved with a hardship waiver without leaving the country?
Absolutely. Well, today's story, the client is already out of the country, but we have plenty of success stories where waivers have been approved before they leave.
Okay. My pending case is a G325A. On the website, it's a G28. What's the difference? I'm trying to look up my processing time.
A G28 is an attorney representation saying that somebody represents you to file. So hopefully that helps. So if you don't have an attorney, you shouldn't have a G28. So there's something wrong there.
Okay, interesting. How long will it take to get a green card if you marry a U.S. citizen? Let's say you're in Pakistan.
If you're in the U.S. and you file the 405 adjustment of status, to get a conditional green card, we estimate between a year to a year and a half. That's like a really long. We've seen some as fast as like 9 months. If you're overseas and waiting for the I-130, and then you have to wait for the National Visa Center and Consulate, it could be 2 years.
When should I give myself to come back from the expiration date with advance parole? Like how much earlier before AP expires should I come back?
CBP officers have continuously said, as long as it is valid, you're able to enter, assuming all things are valid, right? Everything else is valid as well. So, I remember asking the specific question. Somebody who married to a U.S. citizen, they got a conditional green card, or actually they're in the process of getting the green card. They got the advance parole and they left, and it's been 2 years. The green card hasn't been approved, but the advance parole is still valid. Can they come back? And the CBP officer told us yes. And it's like, wow, that's pretty cool. But here's the flip side of that. The moment the advance parole gets expired, even by 1 day, they do not have the authority to let you in. In the past, they could let you in on a humanitarian parole. That got canceled in January of this year. So you will be extremely stuck outside if your advance parole is expired.
Are processing times increasing? And if so, why?
On the contrary, we've seen processing times decrease significantly for a lot of different case types. So EB-5 investments have dropped significantly. Green card, marriage applications, USCIS applications, citizenship applications, even reinstatements, things we were seeing processing time reduced by half or even more. There's a lot of explanations, but my guess is just as good as your guess, but certain cases have been longer, right? But even immigration court, it has been shortened because they're under a lot of pressure to adjudicate these a lot faster.
How hard is it to get a hardship waiver approved?
Expect it to be extremely hard. Prepare your butt off because the processing time is extremely long. But with that being said, our firm's approval rate is like over 95, 98%. We had a case that got denied and we refiled and it got approved. But again, it depends on everybody's situation. It depends how much work you put into it. My suggestion is do your best and do it well. We've seen some waivers filed that's like just 50 pages, 30 pages. Ours is usually 500 to 1,000 pages. How do you gauge, right? So my recommendation is do your absolute best because it's your one chance to get a green card.
I filed for a green card, and today I received a letter to court. What should I do? Will they deport me?
If they're going to deny your green card, and they will deport you, yeah. So if you got a notice of intent to appear, there is a chance that they want to deny your green card. And without lawful status, then they will put you into immigration proceedings to deport you.
Is it true that even marriage-based green card cases are getting denied?
Of course. Marriage cases are getting approved and denied on a daily.
We are both on H-1B, and we recently gave birth. Can we apply for a change of status through our child?
Not now, right? The child not, unless this happened 20 plus years ago. So the child needs to be old enough to petition you. If they're just a newborn, they don't have the right or privilege to petition you yet.
Oh, I didn't know that. My 730 was transferred through a different location and is finally at a local office. What should I expect?
We don't do a lot of the removal defense stuff, so I can't give you the logistical details of what happens after.
My pending case says it's still being processed, but at first it said it's being reviewed. What is the difference?
I wouldn't think too much into it. Somebody is now looking at your case is the main difference.
My friend's brother was deported back to Pakistan from Boston Airport. He had a green card, but he also has charges against him.
So what happened most likely is that the officer found this individual to be inadmissible because of the criminal offense. And so they did not let him come into the country. Probably gave him the option to say, hey, we think you're inadmissible. You could come in, but you have to go through immigration court. You might have to be detained. You can fight for your rights with the immigration judge. And if you prove your case, then the immigration judge will give you back a green card. Do you want to, yay or nay? This individual probably said, nah, forget that. I'm not going to stay in detention center, so went back.
EB2 self-petition, ? I have a bachelor's in mechanical engineering, 2 masters in STEM, NASA awards plus references, German citizen, STEM OPT.
Awesome. Well, I think we just did a case very similar to that, and it got approved. The NASA part is the most interesting. But again, look into the NIW requirements, right? What do you plan on doing, right? If you don't have any plans, your case will probably fail. Whatever your plans are, can you back it up with documents? And specifically now with this new Trump card, can you make the argument that what your plans are is equal, if not better, than giving the US government $1 million? Before, we never had to make that argument. Now try to. Or in the alternative, and I guess you can also say, my contribution, my plan is of such national importance that you cannot be quantified by monetary value. But if you want to, it is far exceeding of $1 million, and this is why. So do that in the conclusion part.
What are some common reasons why marriage cards get denied?
Perfect question. Let's talk about red flags. Red flags are basically anything that the officer really deems that, oh, this is kind of fraudulent, it's kind of fishy. They already assume 9 out of 10 is bad or fraudulent. But if you have any red flags, it gives them additional grounds to deny the case. So what are some red flags? If the petitioning individual, the U.S. citizen or the green card holder, had filed bankruptcy before, right? They're financially strapped. They are subject to a bribery. So if you look through immigration law in history, you'll see there are plenty of U.S. citizens, homeless people who have been bribed a couple $1,000s, and boom, of course, they're signing anything. So if the financial situation on the U.S. citizen side doesn't look good, that's a red flag. Second red flag, tangentially related to that, if socioeconomically the two individuals just does not match. And again, they go by all statistics. So If the female has a really high earning power and the male does not, and the male is the one who's sponsoring the female, and the male, even though it didn't file bankruptcy before, but is just in comparison completely in a different class, that is suspicious. And so if you just go through the statistic route that they do to scrub these cases, you'll see the different red flags pop up. Some are race, some are finances, some are education, and also if you live in different places, right? So if you petition each other, but you live 50 miles apart, and you have two different residents, that's highly suspicious as well. If the relationship is short, if you have any other complications in your immigration file, that's a red flag. So these are all things where the officer will raise the bar and require you to prove a lot more that your case is real. Hopefully that helps. Do not just go based on a template online that you see, I have a few joint documents and this should totally be enough. Plenty of people have tried the immigration fraud route and gotten denied, and it's really bad because it will stain your history for the rest of your life. So prepare your case well. Today's success story is about a husband and a wife, and they got married and they were going to the consulate, and the wife's case got denied for fraud and misrepresentation. They were devastated, they're separated, and now they came to us to file for a 601 waiver while being separated. We filed the case in 2022. We started preparing in early 2022, prepared for a good half a year. We filed it, and just 10 days ago, it got approved and consulate approved them. It's a long time. There was no request for evidence, but it's a long battle. Now you ask, how can the government waive fraud and misrepresentation? And what did you do? Well, it was a very sympathetic case. The U.S. citizen spouse in the U.S. had a couple prior marriages. Again, he was dating her. And in this long-distance, cross-country relationship, the new spouse didn't know all the details to the prior divorces and marriages, and it was kind of complicated, to the point where I had to read multiple times and draw out a chart to kind of be very clear. Ultimately, she did not answer to the satisfaction of the consular officer, and the consular officer slapped the fraud and misrepresentation case on her. And now the only way for her to come to the U.S. is by filing a 601 waiver, essentially proving that without her here, he would suffer extremely. His hardship would be excessive, extreme, and that, therefore, the U.S. government should forgive her misrepresentation, give her a green card so she could be reunited with this husband who is a U.S. citizen. It's a very difficult argument to make. They don't live together. They're already very old at retirement age. He's lived without her for so many years. He had so many previous relationships. There's no crazy amount of arguments. He was a blue-collar worker. There's not a lot of finances involved. So how can you prove that these two older seniors deserve each other, need each other, and without this individual, in this political climate, a Chinese national who committed fraud and misrepresentation on a marriage case can get a waiver? We spent the first part of this waiver application, I have it right here, talking about how it was not fraud and not misrepresentation. Again, it was a confusing marital history. This is what she said. This is what the officer believed. At best, this case is just a misunderstanding, not fraud and not misrepresenting. Even if she did say the wrong date for the meeting and the divorce, how does that help prove the case is fraudulent anyways? So anyway, we went in detail to talk about that it was not fraud and misrepresentation. But we spent the rest of the application talking about the hardship that he would suffer, because that's what's required in the application. We talked about the financial hardship, that this is his last leg of his life. He lived a very complicated romantic history in his entire life, multiple divorces, but the man has changed, and he suffers incredible regret if he cannot bring his last love to the U.S., and there's nobody to take care of him He's a very lonely individual who greatly needs his spouse. And when the time of the initial visa interview back in 2021-ish, it's already been 4 years. And so this marriage is bona fide. It is real. They continue to see each other, and it's just extremely difficult for him without her, right? So we went in depth. Let me kind of go through some of the details. And we got this just so that, all right, let me see. Let me go through the exhibits, because I think that's what a lot of people care for, right? So here's the different sections. We proved that there was extreme medical hardship on the U.S. citizen spouse. We proved extreme marital hardship. We proved extreme financial and career hardship, especially talking about if he had to move back to China. He's been here for his entire life. If he had to move there for his, the rest of his life, that would be extremely hard. And the valuable assets, the U.S. and the good moral character of this female individual, the wife, and what their contributions are, right? We spent about 6 months really understanding their marital history, their financial history, their extreme hardship, why the husband cannot move to China, why she cannot be here, the consequences on his life for the rest of his life. Prepared all of that, and we filed it. And again, finger crossed, we don't know if something like this could get approved. And the political climate is constantly changing. But after 3 years of adjudication, it just got approved. And now they're finally able to reunite. That's the beautiful thing about immigration. You could say, oh my goodness, such a small little mistake. Couldn't they have just cleared it up in 2022, go back to the embassy and clear it up? Honestly, no. The embassy would not accept it, would not accept a second application, would not accept them. And they just seen too much fraud in this arena. And you can consider that this is just a system punishing this individual. And to them, there's it's unbelievable. It was a marriage to a U.S. citizen. It's a wrong answer. And now we have to wait an extra 3 years. We have to file this crazy big hardship application. But that's what the immigration law requires. But it still worked, right? And so as long as it's a little bit extra delay, and you almost cannot blame the immigration system, because there's just so much fraud where people do these fake marriages. And so on paper, he's already petitioned different people. He's already had different marriages, previous divorces, and the applicant answered wrong. He just didn't look like the best candidate. And so now he was forced through this extra couple years. But ultimately, the case got approved. He was able to finally be with his wife again. So I want to encourage anybody who has a very sympathetic situation, or when you're doing your case, do it well, because it's not about whether it's true or not for you. You know it's true, but it's about what the officer has seen right before your case, right? The officer adjudicates all these fraudulent cases, and if they have prepared their case better than yours, then of course you might have to suffer. So do your case well. Go above and beyond in your interview practice, in your application preparation, and really prove beyond a reasonable doubt that your case is completely above board. And know that if it's still denied, there are still these different options that can help correct it, right? The immigration system self-corrects, and that's a beautiful thing about immigration law, because there's so many avenues to still get approved. It might be a little bit longer, but it still can be done. So this is how a 601 fraud and misrepresentation case was able to be overturned, and how this family is able to reunite. And the crazy thing, they don't even live together, right? They haven't ever lived together, because he wanted to petition her to come here to live together. So they got married, and never once did they live together at their senior years. But the case still got approved. I love it. I love it, love it. Thank you for watching. Take care. Bye-bye.